For 20 years I lived on the land my father left me, and in all that time I never paid a single dollar to the Briar Glen Homeowners Association. Then Celeste Harrow showed up at my gate, looked at my truck like it was garbage on her lawn, and told me I had 7 days to sign, pay back dues, or lose my home. She walked into that courtroom certain she had already won, wearing the kind of smile people wear when they think the outcome was decided before anyone sat down. But when the judge opened the deed I set on the table in front of him, he looked at Celeste, then at her lawyer, and he laughed out loud in front of the whole room. Because Briar Glen didn't own me. Briar Glen owed me. If you like watching an arrogant homeowners association president get taken apart by the very paperwork she ignored, stay with me, because this one gets good. My name is Nolan Vance, and I have spent most of my life on 9 6/10 acres of land in Cedar Vale County, North Carolina, in a house my father built with his own hands. The land sits almost dead center inside a neighborhood called Briar Glen, a place full of brick mailboxes, matching shutters, and a homeowners association that controls everything from grass height to the color a man is allowed to paint his shed. My father sold most of the pasture around our house to a developer 2 decades ago, but he kept the house, the workshop, and the ground it stood on, and he made sure that piece of paper said exactly that. I grew up watching him restore old barns and repair furniture other people had given up on, and I took over that trade when he passed, running a small workshop out of the same building he built when I was a boy. For 20 years I lived beside Briar Glen without a single complaint from anyone who mattered. I let maintenance trucks use the dirt road that runs along my north property line because it saved everyone time and because it never cost me anything to be decent. I helped a neighbor's fence back up after a storm one October without being asked twice. When the association planted a row of hedges near the edge of my property, I didn't say a word, because being difficult over a few bushes never seemed worth the trouble. Every board president before Celeste Harrow understood exactly where my land stood, legally and otherwise, and not one of them ever sent me a bill, a ballot, or a violation notice, because there was nothing to send. One of them, a retired school teacher named Ruth, used to stop by every spring just to admire whatever my father had been restoring that season, and she always made a point of telling new residents that the Vance property was its own piece of ground, separate from Briar Glen in every way that mattered. That kind of quiet respect was the only relationship I ever expected to have with the neighborhood surrounding me, a fair trade of courtesy for courtesy, with no paperwork required on either side. That piece ended the afternoon. Celeste parked a black SUV in front of my workshop without an appointment or a greeting. She stepped out in heels that had no business on gravel and looked at my truck, my house, and the stacks of drying lumber like she was inspecting something she intended to condemn. She told me Briar Glen had completed a, quote, boundary reassessment, and that my house had been found to sit inside the community after all. Then she handed me a membership packet, along with a bill for back dues totaling $38,000, as though 2 decades of silence had just been converted into an invoice. I told her, calmly, that I had never been a member of her association, and never signed anything saying I was. She gave me a thin smile and said I had been living off the value other people built around me for 20 years without contributing a cent, and that it was time I stopped acting like a man too poor and too simple to understand how a neighborhood worked. She gave me 7 days to sign the packet, warning that refusal would bring daily fines, a lien on my property, and a court order forcing compliance. As she turned to leave, I noticed something on the boundary map clipped inside her folder, a new line drawn in red ink that ran straight through the middle of my own house. I decided that before I panicked over any of it, I would go hear her explain herself in front of the board, so I showed up at the next Briar Glen meeting, with copies of 2 decades of county tax records proving my property had always been assessed separately from the association. Celeste made sure my item sat dead last on the agenda, so I spent over an hour listening to arguments about curtain colors and the maximum legal height of a hedge before anyone said my name. When she finally called on me, she introduced me to the room as, and I remember the exact phrase, the non-compliant owner of Parcel 7, and put up a projector slide showing a map where my entire property had been shaded the same color as every other lot in Briar Glen. In front of dozens of my neighbors, she listed my sins one at a time. My truck, she said, was lowering property values just by being parked in view of the street. My workshop might be operating without a proper home business permit. My fence, built the year my father died, failed to meet the community's current aesthetic standards. I had, in her words, enjoyed the security and the curb appeal of Briar Glen for 2 decades without paying a cent toward either one. I asked her, in front of everyone, exactly whose signature she had on file proving I had agreed to join, and she said that living inside the community's boundary line for 20 years created what she called an implied consent. A few board members shifted uncomfortably in their seats, but no one challenged her, because nobody in that room wanted to be the next name on her list. One older gentleman near the back, a man named Harold who had lived in Briar Glen since before it even had paved streets, raised his hand and asked quietly whether the board had actually confirmed Parcel 7's legal status with the county before printing that map. Celeste answered him without ever looking his way, saying the matter had already been settled by staff and did not require further discussion, and Harold sank back into his chair the way a man does when he already regrets speaking up. She offered me what she called mercy, a reduced penalty if I signed the packet on the spot, in front of everyone, before I had time to think it through. When I declined, she snapped the folder shut and said, loud enough for the whole room to hear, that men like me always confused stubbornness for knowledge. I didn't argue with her. I simply asked the board secretary for a copy of the meeting minutes and every document Celeste had just presented, and on my way out, her attorney, a polished man named Landon Price, handed me the first official legal notice of the dispute. Buried inside that packet was a line I almost missed, a reference to a title company report Briar Glen had commissioned 6 months earlier to review my property, but the conclusion of that report had been carefully cut out of the copy she made public. That single missing page told me this wasn't some innocent misunderstanding born out of a careless survey. Somebody had gone looking for something on my land long before Celeste ever knocked on my door, and whatever they found had been important enough to hide from her own neighbors. Driving home that night, I kept turning over one detail that bothered me more than the fines or the red boundary line. Celeste hadn't stumbled onto my property by accident during some routine review of the neighborhood. Somebody had gone looking specifically for me, months before that folder ever landed in my hands, and had decided whatever they found was worth burying rather than sharing with the very residents she claimed to be protecting. My father used to say that people rarely lie about small things unless the truth attached to something bigger frightened them, and by the time I pulled into my own driveway, I had already decided to find out exactly what that bigger thing was. I spent the next 2 weeks trying to understand why, after 20 years of silence, Briar Glen suddenly needed my land to belong to them. What I found was a proposed clubhouse expansion, a $3.8 million project that included a new banquet hall, a sports court, and an expanded parking lot, all championed personally by Celeste as her signature achievement as president. To fund it, the association needed a large construction loan, and the bank underwriting that loan required proof that Briar Glen held stable, long-term access to 3 specific areas critical to the project. Every one of those 3 areas ran directly across my land: the fire access road behind the clubhouse, the main drainage ditch running down the hillside, and a strip intended for the new parking entrance. Without my signature confirming that access, The bank could not treat it as permanent or secure, and a temporary easement built on a stranger's goodwill was not something any underwriter would bless. Instead of coming to negotiate with me honestly, Celeste decided it would be simpler to force me into membership, because a member's land could be governed by board resolution instead of by a private agreement with an outsider. I also learned she had already promised residents the expansion would require no increase in dues, a promise that could only survive if she found some other source of funding, and my forced membership fees were apparently part of that math. If the loan fell through, her signature project, and likely her presidency, would collapse with it. I pieced most of this together from public meeting minutes and a friendly clerk at the county planning office who let me sit with the permit file for an afternoon. The clubhouse renderings were glossy and ambitious, with a banquet room that could seat 200 people and a parking lot large enough to make my 9 acres look small by comparison. Every rendering showed the new entrance cutting directly across the corner of my property, as though the architect had simply assumed the land would eventually belong to Briar Glen one way or another. Seeing my own workshop erased from a set of blueprints I had never been shown made the whole thing feel less like a paperwork dispute and more like watching someone quietly plan to take my house out from under me. While I dug through property records, Celeste kept the violation notices coming, each one dated as though I had already been a paying member for years. One cited my truck for being parked outside during daylight hours. Another fined me for a workshop roof that didn't match an approved color palette I had never seen or approved. A third claimed I never filed for a permit to run a home business, despite the fact that my father had run that same workshop since before Briar Glen existed. A fourth measured my fence at 3 inches over some limit that had never once been enforced against me before that spring. I called Landon Price directly and asked him one simple question: whether he could produce a single document bearing my signature agreeing to join the association. He didn't answer the question at all. He told me the matter would be resolved in court, which told me everything I needed to know about what he did and did not have in his file. That night, sitting alone in the kitchen my father had built, I remembered something he told me not long before he passed, that if anyone ever came asking about the North Road, I should open the blue box in the workshop safe. I hadn't thought about that box in years, but I found it exactly where he said it would be, tucked behind a stack of old receipts and tool warranties. Inside was a sealed envelope with my father's handwriting across the front, a single line that read, "They will pretend to forget this part." My hands were not entirely steady when I opened it, because some part of me already understood that whatever was inside had been waiting 20 years for exactly this moment. What I found was the original county-recorded deed from the day my father sold the surrounding pasture to the Briar Glen developer. The paper yellowed at the edges, but the notary seal and file number still perfectly legible. The main body described the boundaries of my land in careful, technical language, but the real weight of the document sat in an appendix most people would have skimmed past. The first clause stated, in plain terms, that Parcel 7 was retained as an independent property and would remain permanently exempt from any Briar Glen governing documents, regardless of future development around it. The second clause went further than I expected, stating that no vote, resolution, or bylaw amendment adopted by the association could ever annex Parcel 7 without the notarized, written consent of its owner. Silence, the use of shared roads, or the receipt of any community service could never be interpreted as that consent. I sat with that page for a long moment before I noticed the third clause, tucked beneath a survey diagram of the North Road, and that was the part that changed the shape of the whole fight. Briar Glen had been granted a limited right to use a section of dirt road and drainage ditch crossing my property, but only for maintenance, drainage, and emergency access. In exchange, the association was required to keep that road in good repair, cover the cost of any damage its vehicles caused, maintain the drainage clear of debris, and never expand or repurpose that access without the landowner's written approval. For years, that road had been left to crumble under the weight of maintenance trucks, and the drainage system had been quietly eroding a corner of my own property, with nobody so much as mentioning it. Celeste's own association had been violating that agreement long before she ever accused me of violating anything. I drove straight to the office of Tessa Quinn, a real estate attorney a friend had recommended years earlier for a boundary dispute that never went anywhere. She didn't react with excitement when I laid the deed on her desk, which I later came to appreciate, because Tessa never celebrated anything until she had verified it herself. She pulled the file number, called the county recorder's office while I sat there, and cross-referenced the survey diagram against current parcel maps before she said a word about strategy. Only after she confirmed every seal, signature, and filing date checked out did she finally look up at me. Celeste, she told me, hadn't just sued the wrong man. She had asked a court to grant her association a power that the very document creating Briar Glen had explicitly forbidden it from ever holding. Tessa warned me the fight wouldn't end there, because associations with deep pockets often drag disputes out for years, hoping the smaller party runs out of money or patience before the truth does any good. I told her I didn't want their money and never had. I only wanted them to leave me alone, and she tapped the road clause with one finger and said that after everything they had just done, leaving me alone might turn out to be the most expensive option they had left. Tessa sent a formal letter demanding Briar Glen drop every fine, confirm in writing that I was not a member, and remove my name from any violation log they kept. She attached a copy of the deed's main page but deliberately held back the road appendix, wanting to see how far Celeste would push before showing our full hand. Celeste didn't back down for a second. She wrote back claiming the exemption clause had, in her words, lapsed once the community developed around my land, as though geography alone could rewrite a recorded legal document. Landon Price cited a board vote from 12 years earlier in which the association had approved expanding its official community boundary to include several outlying parcels. Tessa's response was simple and, I thought, satisfying. She wrote that Briar Glen could hold as many internal votes as it liked, but no private meeting of homeowners had the legal authority to alter a recorded deed belonging to a man who was never a member and never invited to vote. Celeste then requested what she called a mediation session at the clubhouse, insisting I come alone, though I arrived with Tessa at my side anyway. Through the entire meeting, Celeste spoke only to me, as though Tessa were furniture rather than my attorney. She offered to cut the back dues in half, give me 3 years to bring the property, quote, up to standard, and waive the initial membership fee entirely. In exchange, she wanted my signature acknowledging Briar Glen's authority over my land and formally approving the clubhouse expansion project. She called it the last chance for me to, in her words, act like a reasonable adult about all of this. I asked her a question that seemed to catch everyone in the room off guard: why she needed my signature at all if she already believed I was a member. The room went quiet in a way that told me the question had landed exactly where it needed to. Landon immediately called for a recess, and Celeste, visibly rattled, snapped that I clearly wasn't intelligent enough to understand the larger financial issues at stake. I turned down her offer without raising my voice, and the very next day, Briar Glen formally filed suit, asking the court to declare me a mandatory member and to authorize a lien against my property for the unpaid dues. Tessa filed our countersuit immediately, asking the court to declare the association had no authority over Parcel 7, to award us attorney fees, and to address the ongoing violation of the road maintenance agreement. During the discovery process that followed, we finally received the full title report, Briar Glen had commissioned 6 months before Celeste ever appeared at my gate. The final page carried Celeste's own signature directly beneath a line stating, in language even a courtroom stranger could not misread, that Parcel 7 could not be annexed without the owner's notarized consent. With the lawsuit clearly not going her way behind closed doors, Celeste shifted tactics and started working the neighborhood instead of the courtroom. She sent a community-wide newsletter describing me as a man trying to seize public infrastructure for himself, never once mentioning that the road in question actually crossed my own private land. She claimed instead that I was threatening to block emergency vehicle access to half the neighborhood, a framing designed to turn frightened homeowners against me before anyone checked the facts. A few of my longtime neighbors began giving me strange looks at the mailbox, and one family left a note on my door asking me to stop being selfish. A woman named Diane, who had brought over a casserole the week my father died and had waved at me from her porch nearly every morning since, crossed the street to avoid walking past my driveway, and that one small change hurt more than any of Celeste's fines ever had. I told myself it wasn't really about me, that people were scared for their own property values and their own peace of mind, and that fear makes otherwise decent folks believe things they would never believe on a calmer day. Celeste even led a small group of residents down to my property line to photograph the road, as though gathering evidence for a cause she had already convinced them was righteous. I never once blocked that road, and I never intended to, so I put up a simple hand-painted sign near the entrance, stating that the road remained open to residents, and that the dispute concerned only the association's misuse of an agreement, not public access. Celeste seemed almost angry that I refused to play the villain she needed me to be, because a calm landowner is a much harder story to sell than a greedy one. She escalated further by sending a landscaping crew to mark a row of old oaks on my property with orange tape, apparently intending to clear them for the expanded clubhouse entrance before any ruling had even been made. I filmed the whole crew, asked them to leave my land immediately, and sent the footage straight to Tessa that same afternoon. She filed for an emergency restraining order preventing Briar Glen from altering anything on my property while the case remained open, and the judge granted it within 2 days. During a deposition not long after, Celeste's contempt for me came through even more plainly than it had at that first meeting. She told the room I lived, quote, outside the community's standards, that my old house was an embarrassment to the neighborhood and that it was unfair I benefited from rising property values I had done nothing to earn. Tessa asked her, calmly, whether my property value benefiting from Briar Glen's presence gave the association any legal claim to my land. Celeste tried to sidestep the question, so Tessa placed the signed title report directly in front of her and asked her to explain her own signature beneath the consent clause. Celeste admitted she had read the report but insisted the board had every right to, in her words, correct a historical oversight. When Tessa asked what oversight she meant, Celeste's answer told us everything we needed about her actual motive. She said, without much hesitation, that one man should not be allowed to stand in the way of the community's future. That single sentence confirmed what we had already suspected, that Celeste hadn't made an honest mistake at all. She had known exactly where I stood legally from the very beginning, and had simply decided her ambitions mattered more than my ownership. Landon requested a short break after that answer and quietly asked Tessa, away from the recorder, whether I would be willing to settle before the road appendix ever made it in front of a judge. Briar Glen's formal offer arrived a few days later, and it was larger than anything they had proposed before. They offered to erase every fine, cover a portion of my legal fees, and pay me $75,000 outright if I signed away my independence for good. The agreement required me to join the association permanently, approve the road expansion without restriction, waive any claim related to the drainage damage, and keep the entire settlement confidential. Celeste seemed convinced the number alone would be enough to end the fight. She slid the contract across the table during our next meeting and told me it was probably the largest sum of money I had ever seen in my life. I wasn't angry when I read it. I simply flipped to the final page and asked her why an association, claiming it already had the authority to control my land, would need to pay $75,000 to purchase that exact authority from me. She answered that they were paying for my cooperation, not for ownership itself, a distinction that sounded thinner the longer I sat with it. Landon shifted in his seat when she said it, and for just a moment I caught something on his face that looked less like confidence, and more like a man watching his own client talk herself into a corner. I asked Celeste one more question before I pushed the contract back across the table, whether she had shown her own board the full title report before asking them to approve spending $75,000 to buy my silence. And she did not answer that one either. I turned the offer down without much debate, and afterward Tessa reminded me that winning in court wouldn't automatically make every problem disappear. Briar Glen still had the resources to appeal, or to manufacture some new dispute down the road, so the cleanest ending would be a ruling specific enough to settle both my membership status and the road agreement for good. While preparing our witness list, Tessa suggested we track down a retired surveyor named Wyatt Granger, who had worked on the original Briar Glen land division 2 decades earlier. Wyatt still kept his old survey logs in a filing cabinet in his garage, yellowed but perfectly organized. He confirmed that the original developer had actually offered my father the chance to fold our property into the association back when the deal was first negotiated, and my father had refused. He didn't want his son bound by rules that hadn't even been written yet. And that refusal was exactly why the developer's own attorney had drafted the exemption clause in the first place. Wyatt still had the original survey map, signed by every party involved in the transaction, showing Parcel 7 marked out in plain white space against the shaded outline of the rest of Briar Glen. It was a striking contrast to the version Celeste had projected at that very first board meeting, where the boundary line separating my land had simply vanished, replaced with the same uniform color as every other lot. Tessa never accused Celeste of forging the map outright, but she made it clear we intended to ask, under oath, exactly who requested that change and why. She didn't have to wait long for the answer, because discovery turned up an email Celeste had sent to the mapping vendor months earlier, dated only a few days after that first board meeting, where she stood in front of the whole neighborhood and called me non-compliant. The email read, almost word for word, "Remove the exemption section. Residents don't need to be confused by an outdated detail." Reading that line for the first time felt like watching the last piece of a puzzle fall into place, because it removed any possibility that Celeste's actions could be explained away as confusion or carelessness. She had known the truth, made a deliberate choice to erase it from public view, and pursued the fight anyway, because she believed I would never find the paperwork to prove it. That single sentence became, in Tessa's words, the backbone of everything we would present at trial. Once Landon learned that email would be entered as evidence, he tried once more to talk Celeste into dropping the entire lawsuit before it reached a courtroom. She refused, convinced that backing down now would end her presidency and bury the clubhouse project for good, and in her mind, both outcomes were unacceptable. She sent me one final proposal, this time agreeing in writing that I was not a required member of the association, but demanding I sign over unrestricted, permanent rights to the road running through my land. I turned that down too, because unrestricted access would have let Briar Glen widen the road, run heavy construction equipment across my property, and alter the drainage system entirely without ever asking my permission again. The night before the trial, The pressure finally caught up with me in a way it hadn't during all the meetings and letters that came before it. I wasn't a wealthy man like most of my neighbors in Briar Glen, and the legal fees had already eaten into savings I had spent years building. I sat at my kitchen table wondering, honestly, whether I should have taken the money and let the whole exhausting fight end quietly. Tessa reminded me over the phone that this had stopped being about a few fines or a membership fee a long time ago, and that signing away the road clause would hand a private board the power to decide the future of the house my father had spent his life protecting. I opened the blue box one more time that night and read my father's handwriting under the porch light. "They will pretend to forget this part," he had written, and sitting there in the quiet, I finally understood what he meant by it. He hadn't left that deed behind so his son could cash in on a lawsuit years later. He left it so that his son would never have to ask anyone else's permission to exist on his own land. I thought about the years he spent building that workshop board by board, teaching me to sand a joint smooth and to never rush a repair just because a customer was impatient. He never had much money and he never wanted much, but he wanted this piece of ground to stay exactly what it was, a place nobody could tell him how to live on. Sitting at that same workbench decades later, I understood that walking away from the fight would have meant walking away from him too, and that was never a trade I was willing to make, no matter how tired I was of lawyers and letters and folding chairs in county buildings. The morning of the trial, Celeste arrived in a cream-colored suit, flanked by several board members who had clearly been asked to show up for support. She smiled when she saw me standing outside the courthouse in my plain jacket, the kind of smile that assumes the outcome has already been decided in her favor. As she walked past me toward the entrance, she leaned in just enough for only me to hear and said that after today, I would finally have to follow the same rules as everyone else. I told her that was exactly what the deed was about to decide, not her, and I watched something flicker across her face before she straightened her posture and walked inside. The courtroom was small and plain, nothing like the marble hallways people imagine when they think about trials, just wood paneling, a tired ceiling fan, and rows of folding chairs half filled with curious neighbors who had heard rumors about the case. Celeste sat straight-backed at the plaintiff's table with 3 board members lined up behind her like a jury of her own choosing, while I sat beside Tessa with nothing in front of me but a manila folder and the blue box tucked safely under the table. Judge Kincaid entered without ceremony, glanced briefly at both tables, and told everyone to get comfortable, because he intended to hear this one all the way through before making up his mind about anything. Landon opened by telling Judge Everett Kincaid that Briar Glen possessed what he called undisputed authority over my property, citing 2 decades of residency inside the community's general boundary as proof enough of my obligation to join. Judge Kincaid asked him directly whether he had any document bearing my signature or my father's, agreeing to that membership, and Landon had nothing to offer. He pivoted instead to the argument that my silence over 20 years amounted to an implied consent, the same phrase Celeste had used against me from the very beginning. Tessa stood and placed the original deed directly in front of the judge, asking him to read the section stating plainly that silence, shared utilities, or geographic proximity could never substitute for written, notarized consent. Judge Kincaid read the clause once, then read it again more slowly the second time, the kind of pause that told everyone in the room he had noticed exactly what mattered. Landon tried to argue the clause no longer applied, insisting the neighborhood's growth around my property had somehow rendered it obsolete with the passage of time. The judge looked up at him and asked whether Briar Glen genuinely believed that building homes around a piece of land could erase that land's recorded deed. Landon answered that the ornamental boundary markers and the Briar Glen signage now physically surrounded my house, as though decorative stonework carried the same weight as a courthouse filing. The judge looked from the map to Celeste and asked, in a tone dry enough to cut glass, whether the plaintiff's actual position was that a brick wall could amend a county's property records. He laughed then, short and sharp, not out of amusement so much as sheer disbelief at what he was being asked to accept as legal reasoning. The courtroom went completely silent, and I watched Celeste's face go red as every eye in the room shifted toward her. Tessa didn't waste the moment, moving straight into the original survey map, the signed title report, the email demanding the exemption be erased, the road maintenance appendix, and clear evidence Briar Glen had neglected both the road and the drainage system for years. Celeste's face had gone from confident to pale in the space of a single hour, and I watched her hands tighten around the edge of the table as Tessa laid out one document after another. Landon tried twice to object to the email being entered as evidence, arguing it had been taken out of context, but the judge overruled him both times without much patience left in his voice. By the time Tessa finished, even the board members sitting behind Celeste had stopped looking at her and started looking down at their own folded hands. Judge Kincaid asked Celeste directly why she had pursued this lawsuit at all, when she had personally signed a document acknowledging she needed my notarized consent to do exactly what she was asking the court to grant. She answered that one man shouldn't be allowed to stand in the way of hundreds of families and their future, the same justification she had given Tessa months earlier under oath. The judge told her, plainly, that ownership was never decided by how many people wanted to take something that belonged to someone else. He ruled decisively, declaring that I was not, and had never been, a member of Briar Glen, and that the association had no authority to fine me, place a lien on my property, or enforce any of its regulations against me. Just as Celeste began gathering her papers, believing the hearing was finished, the judge opened the final appendix and asked Landon whether they ought to discuss the road his client's association had been using on the defendant's private property without honoring its own terms. The court confirmed that Briar Glen's access to that road existed only under the exact conditions written into the original deed, nothing broader and nothing assumed. The association could not widen it, repurpose it, or alter it in any way without my direct written permission, regardless of how badly the clubhouse project needed that access. Judge Kincaid ordered Briar Glen to erase every fine against me, remove all lien filings, cover the majority of my legal costs, repair the eroded section of my land, restore the road to proper condition, and stop telling residents I had ever threatened to block emergency access. Compensation for years of unmaintained road and neglected drainage was set aside for a separate settlement, since I had never asked to shut the road down or make life difficult for the families who actually lived there. Within a week, several board members discovered that Celeste had known the true legal situation the entire time and had spent association funds pursuing the lawsuit regardless, which did not sit well with people who trusted her with their dues. She was pressured into resigning during an emergency board session called specifically to address what members were calling a serious breach of trust. The clubhouse expansion project was placed on indefinite hold, and the new leadership that stepped in came to my house not with violation notices, but with a genuine proposal for cooperation. I agreed to let Briar Glen continue using the road under a new written agreement, this time with real limits attached. They could not widen it without my consent. They were responsible for its upkeep going forward. Every future change had to be documented in writing, and no future president could ever again use that access as an excuse to claim I was somehow a member. Celeste and I crossed paths one final time when she came to clear out her office at the clubhouse, and she told me I had cost the entire community millions of dollars just to prove a point. I told her that wasn't quite right, that she was the one who cost them all that money. because she assumed a man in work boots and a beat-up truck would never bother reading his own paperwork. I drove my old truck through the Briar Glen gate that afternoon, and the sign still stood exactly where it always had, but the boundary on the official county map had finally been corrected to match what my father's deed said all along. Some of my neighbors, the ones who had signed the petition or left notes on my door, came by the workshop in the weeks that followed to apologize, and I let every one of them in because holding a grudge against people who had simply believed a lie never seemed like a fair trade for peace. Harold, the older man who had raised his hand at that first meeting and gotten nothing but silence for it, ended up joining the new board, and he told me once that my case was the reason he finally started reading every document before he signed it. Back home, I opened the blue box one last time, laid the deed carefully inside it, and closed the safe the way my father used to, the metal door settling shut with the same quiet click I remembered from childhood. I never wanted to be Briar Glen's enemy, and even now I don't think of myself that way, because the fight was never with the people who lived there, only with one woman who mistook a quiet man for an easy one. I only ever refused to become their property, and in the end, that was the only thing that ever mattered. The same 9 6/10 acres, still mine, still standing exactly where my father left them.